Hey guys, this is Royal, and I'm going to kind of scoot along. I think I had planned for us to try to finish the articles and move on next session into the First Amendment. So let's pick up, and I'm just going to move through the articles where we were. We left off at Article 3, Section 2, and we were talking about the judicial power. We're still in the judicial power, the judicial branch. And the judicial power of the United States shall extend to all cases in law and equity arising under the Constitution, the laws of the United States, and treaties. Those are the three main areas: the Constitution, laws of the United States, and any treaties our country enters into. The courts will hear cases affecting ambassadors, other public ministers, and consuls, as well as all cases of admiralty and maritime jurisdiction. And all admiralty and maritime jurisdiction are, or the courts hearing cases concerning ships or the sea and other navigable waterways. So federal courts can hear all of those kinds of cases. They also hear controversies to which the United States is a party. For example, under the Federal Tort Claims Act, if the United States is sued for some reason, those can be heard in federal court. Controversies between two or more states, and controversies between citizens of different states, which is often called diversity jurisdiction, which we'll talk more about later. But the 11th Amendment came and changed one of the clauses here, and it established that federal courts do not have jurisdiction to hear cases involving, say, a citizen of Texas suing the state of Louisiana. That cannot be heard in a federal court. The 11th Amendment, when we get to it, I'll explain that more clearly, but for now, know that the one area federal courts may not hear cases is the area of, in a federal court, it has a lawsuit brought before it from a citizen of, say, Texas to a citizen of the state of Louisiana, a citizen of Texas suing the state of Louisiana. They cannot do that. Also, it's important to keep in mind the types of jurisdiction in all cases involving ministers, ambassadors, and consuls, in which, or in one in which a state may be a party. Then the Supreme Court has what's called original jurisdiction, the most basic first jurisdiction there is. And in all other cases, though, the Supreme Court will have appellate jurisdiction. And all the word appellate means is from the appeals court. So in all those cases, the Supreme Court can hear virtually anything it wants to, but it will do so under its appellate jurisdiction, except for ministers, consuls, ambassadors, other ministers, and when a state is a party. So again, we're talking about when cases can be heard in federal court. The trial of all crimes can be heard, except impeachment, will be heard by a jury in federal court. The trial of all crimes, except in cases of impeachment, will be heard by a jury in a federal court. But the thing to keep in mind about the federal courts is that the federal courts will decide arguments over how to interpret the Constitution, how to interpret all laws passed by Congress. And as I said, federal question jurisdiction is the broad term applied to this. Federal question jurisdiction involves a violation of the Constitution, federal law, or a treaty. So those are all federal question jurisdiction cases. Also, whenever there are disputes between states, again, diversity jurisdiction. The reason the framers wanted to create that diversity jurisdiction is because they thought that if citizens from another state came, say from Texas, brought a lawsuit in Louisiana, it would be best if they could bring it in federal court, because there wouldn't be any preferential treatment from a state court district judge, for example. In federal court, because the judges are life tenured and cannot have their salaries diminished, they would just be more impartial, completely removed and insulated from politics or anything else. So we have federal question jurisdiction, we have federal diversity jurisdiction. These are all instances in which cases can be brought in federal court. And keep in mind, what we're talking about is this process involves the federal district courts where trials are held, the appeals courts, which review things coming up from the district court, and then the Supreme Court, where it has original and/or appellate jurisdiction. So that is when, and a federal court has to have a real case or controversy. It has to have a dispute that's actually affecting a real person, a real litigant, before it can be heard in federal court. In other words, the federal courts are not in the business of offering advisory opinions. They're not just ever going to pronounce, to promulgate different things as an advisory opinion. They have to be deciding a concrete case or controversy, whether it's someone from one state suing someone in another state, whether it's, say, age discrimination, racial discrimination, sex discrimination, something arising under a federal statute. You have to have someone harmed bringing a lawsuit against the defendant. You have to have an actual case. Now, there is something called a declaratory judgment that comes close to offering an advisory opinion, except it involves a concrete dispute. It involves a particular case. So it's not a general advisory opinion. And a declaratory judgment can shorten the need for litigation because the court can determine the rights of the parties before they get full-fledged into a lawsuit or into a litigation. But aside from a declaratory judgment, you have to have an actual case or controversy where there has been concrete harm that has been suffered. And it's important to keep in mind that a federal criminal defendant has a right to have their case tried by jury in the state in which they allegedly committed the crime. So if they commit a crime in Louisiana and they flee to Texas, if the prosecution wants to go get them from Texas and bring them back, in federal court, whether it's, say, a federal drug charge, they can be tried in federal court in Louisiana. That's where they should be tried because the drug crime was allegedly committed in Louisiana. So even if they run off to Texas, they'll bring them back and try them in federal court here because the crime allegedly, that nothing's been proven yet, allegedly was committed here. And that's generally a look at what federal courts do. The federal district courts are really where it all happens. Guilt or innocence gets determined. Juries are called, which is often the case. Juries are such an important part of our judicial system. When you have 6 or 12 impartial jurors listening to evidence and facts after you've put them through something called voir dire, where you question, say from 100 people, you narrow it down to 12 with maybe 2 alternates, 14 people out of 100 after you've gone through and questioned them. Hi, I'm Royal Alexander. I'm one of the attorneys in the case. You don't know me, do you? No. Do you know the prosecutor? No. Do you have any inability to hear a case, say a drug case, and listen to the evidence and only the evidence and render a judgment? But if you know anyone or you have a bias or you say your religion doesn't allow you to render judgment on anyone else, you'll state those cases, state those facts about yourself, and likely either the prosecutor or the defense will use one of their strikes to take you off the jury. But once you go through that process and you've winnowed it down to 12 people, maybe with 2 alternates, who say, yes, we can hear the evidence, yes, we will listen to nothing but the evidence, we will keep open minds, and we will render a judgment based on what the judge tells us. When those juries, when you have done that, that is the closest thing to real substantial justice we have in our justice system. And juries are so important. But that's what gets heard in federal district courts. It gets appealed, and then the Supreme Court can hear something if it wants. That is Article 3, Section 2. Now we're in Article 3, Section 3. Treason is a big part of it, of Article 3, Section 3. Treason is the only crime specifically defined in the Constitution. And according to Article 3, a person is guilty of treason if they were waging war or they're giving aid and comfort to the enemy. That's what constitutes treason, not all the things around it. waging war and giving aid and comfort to the enemy. Those are, but giving aid, keep in mind, includes things like passing classified information on, like when we have spies get arrested, or supplying weapons. Those are considered giving aid and help to the enemy. Passing classified information, supplying weapons, but that's how you define treason. Waging war against the United States or giving aid and comfort to the enemy. But to be convicted, it has to be on the testimony of 2 witnesses, or the individual confesses to having committed those treasonous acts. But keep in mind, what does not amount to treason is vocal, heated, vigorous opposition and protests and demonstrations. That's not treason. In the middle of a war, you can go say, I totally oppose this war. I think my government is wrong for declaring war and committing this nation to war. All of that is not treason. Treason is taking up arms against your country and giving aid and comfort to the enemy. So that's important. Article 4, Section 1, full faith and credit. This is important. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. Now, why is that so important? Well, the full faith and credit clause, Article 4, Section 1, requires the states to respect and honor the state laws and court orders of other states, even if their own laws are different. Now, let me give you an example. Louisiana and Texas. Let me give you a different example. Say New Jersey and Louisiana. New Jersey is generally considered a liberal state. Louisiana is generally considered a conservative state. When we first saw the issue of gay marriage, before the Supreme Court declared gay marriage to be constitutionally, to be a fundamental right under our Constitution, some states recognized gay marriage, but other states did not. Now, because of what the Supreme Court has done, we all recognize, all 50 states. You can decide whether that was correct or not, but all 50 states recognize gay marriage. But before that, New Jersey may have recognized gay marriage, but Louisiana would not allow gay marriage to take place within Louisiana. However, if a gay couple moved from New Jersey to Louisiana, their marriage in New Jersey, their gay marriage in New Jersey would have to be recognized in Louisiana. That's the full faith and credit clause. Another one is, for example, say Mississippi allows marriage to take place at age 16, but Louisiana won't allow 2 people to get married until age 17. Well, if they get married in Mississippi, then move to Louisiana, Louisiana has to recognize the Mississippi marriage as valid in Louisiana, even though in Louisiana, 16-year-olds could not have gotten married. We still have to recognize the Mississippi marriage because of the full faith and credit clause. So it's important that it would be hard for our 50 states to function if we didn't recognize each other's court decrees, marriages, adoptions, child custody, and on and on. It really couldn't, the system couldn't work. That's part of being one of the 50 states in a union, you could say, but we're required by the full faith and credit clause of Article 4, Section 1. Now, Article 4, Section 2. This is important. The citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. Now, what does that mean? Well, what it really means is we're talking about the principle of comity, C-O-M-I-T-Y, comity. What is comity? It's the legal principle. It's broader than a legal principle, but the legal principle of comity involves the fact that political entities, say such as states, nations, or courts from different jurisdictions, like Texas and Louisiana, will mutually recognize each other's legislative, executive, and judicial acts. That's because, again, where people travel, there's a fundamental right to travel. People cross borders all the time. People live in different states. People move from Louisiana to Texas and Texas to Louisiana. But this principle of comity, where we're all going to recognize each other's mainly judicial decrees. That's usually what we're talking about. But what we're really saying is that states cannot discriminate against citizens of other states. In other words, it's a guarantee that, say, Texas cannot discriminate against citizens of Louisiana when they're in Texas. States must not give non-residents, a state must not give a non-resident, treat them differently. On the other hand, a state must give a non-resident the same fundamental rights it gives its own citizens. Again, this is what we're talking about, Article 4, Section 2. Also, when a criminal flees to another state, again, like we talked about a minute ago, the other state has to return that criminal to the second state, has to return the fugitive to the first state. Again, say a criminal allegedly commits a criminal act in Louisiana and flees to Texas. Texas has to return the criminal to be tried here where the crime was allegedly committed. But there's something interesting. Article 4, Section 2 also addresses foreign countries. So say somebody commits a crime in Louisiana, but then flees to, let's not say Mexico, because that's always the example. Let's say Venezuela. Well, Venezuela doesn't have to return the criminal unless in the extradition papers, the state that gets the person, the individual back, the alleged criminal back, may only try the fugitive that Venezuela is returning to Louisiana on those charges named in the extradition papers. So Louisiana may try to extradite, the federal government may try to extradite someone back to try them in Louisiana, for example, but Venezuela doesn't have to turn the person who fled our jurisdiction, left the United States and went to Venezuela. They don't have to return them except based on the agreement in the extradition papers. So, for example, if Louisiana has a death penalty, but Venezuela does not recognize a death penalty, then the extradition papers, before Venezuela sends the individual back, the extradition papers can say, but you may not try them and use the death penalty. You could only try them for murder in your state, in your country, but not offer the death penalty, because we don't have the death penalty in Venezuela, and we're not going to return them to you. This individual who left the United States, left Louisiana, and went to Venezuela, Venezuela is not going to return them to the United States unless in the extradition papers you agree you won't put the death penalty on the table. Just try them for murder and leave life in prison, but the death penalty is off because we don't recognize that. A foreign country has that right to do that. And that's very interesting. That's different. So that is Article 4, Section 2. Now Article 4, Section 3. This is interesting. New states, we have 50 states. New states, though, can be admitted into the Union, but no new state can be formed or erected within the jurisdiction of any other state that exists right now. So we can have new states, but there cannot be a new state that's formed or erected within the jurisdiction of any other state that's a state right now. So, and that's also true, no two states can form a junction and create another state. But a common example, for example, if the state of New York wanted to make New York City is a huge city. I think there's 12 million people in New York City. If New York State, or if New York City itself wanted to become its own state and call itself New York City State instead of New York State, the state itself, New York State, would have to agree to that, and the Congress would have to agree to it before New York City could become its own state. And that's just so crazy things didn't start happening within the 50 states unless the state in which it was occurring and the Congress agreed to allow it. And you'll be hard pressed to allow both the Congress and the state itself to allow another state to be erected within it. But that's interesting. But so that's for states. But keep in mind, the federal government, not all the lands that are owned or controlled by the United States are states. we also have territories. We know that. And there's territories I'll describe in a minute. We also have national parks and national forests. So the U.S. is allowed to control its own national parks and national forests. We know that. But the U.S. can also allow territories to become independent nations, the way that the United States allowed the Philippines to become its own country. However, we also have territories that are not American states, but they are U.S. territories. They include D.C., the District of Columbia, which is the federal district. We've been over that before. Guam, the territory of Guam, and, for example, Puerto Rico. Those are all American territories. They would like to become states probably, but they're not states. They're American territories. DC, Guam, and Puerto Rico are three of the most common ones. And they're still territories. They haven't been allowed to be states, and probably may very well likely never be. I don't think that was their purpose anyway. But the U.S. can allow a territory to become a country, like the Philippines. So that's important to keep in mind when it comes to new states or new territories. Article 4, Section 4 is an interesting article and clause of it. The United States shall guarantee to every state in this union a republican form of government and shall protect each of them against invasion. Now, what's interesting about that is a republican form of government doesn't mean the Republican Party. I know many of us think, oh, that must be what it means, but it's small r, a republican form of government, meaning one that, we know that a republic is based on a constitution. And this has been interpreted, this guarantee clause, scholars have called it the guarantee clause, that we're guaranteed a republican form of government and we're guaranteed for help against invasion. The guarantee clause just means that each state must have a representative democracy, meaning we're not going to have a monarchy. That's what we broke away from England and from Great Britain. We're not having a monarchy, and we're sure not having a dictatorship. So what that means is Article 4, Section 4, where the Constitution guarantees to every state in the Union a republican form of government, that just means a representative democracy. We're going to elect people, probably going to elect state representatives and state senators. We're going to elect a governor. We're going to elect all kinds of other lower positions, mayor, and on and on. But a republican form of government just means we're going to be electing people based on our Constitution, even if it's a state constitution. We're not having a monarchy, and we're sure not having a dictatorship. That's what the guarantee clause means. All right, that's Article 4, Section 4. Now we're moving on to Article 5. Article 5 has a special place in my heart because when I was growing up, just to show you the kind of family I grew up in, I was one of 12, as you may recall. And we, in addition to being pushed, a lot was demanded of us, and academically was one of those areas. But my dad always had a states writer, constitutional person that he was, my late father, taught us about Article 5 from probably the time I began hearing of this thing called Article 5 of the U.S. Constitution, from the time I was probably 10 years old. So while other people may have been talking about the Dallas Cowboys or the New Orleans Saints or what the president's doing, in our family, we may have talked about those things, but we also talked about Article 5. So what is Article 5? It's very important. And it's so important because it's how we amend the Constitution. And I want you to know that what I'm about to describe to you is a difficult process to accomplish. But I think amending the Constitution is supposed to be a difficult process. It's supposed to take a huge amount of agreement to alter our federal national Constitution. In Louisiana, for example, we've amended our Constitution hundreds of times. I don't know the exact number. We actually treat it as a state body of law. I mean, it's the Constitution, but we treat it as though it's kind of a state statutory scheme. That's not what we do at the national level. Our national Constitution hadn't been amended in a long time. And Article 5 is two ways. First, the Congress, whenever 2/3 of both houses, that's the House and the Senate, shall deem it necessary, shall propose an amendment to the Constitution. Both 2/3 of both houses, the U.S. House and the U.S. Senate. And we've talked before about how hard it is to get, for example, in the Senate, 67 senators. And in the House, that means 290 of 435 representatives in the U.S. House. That's hard, but that's the Congress doing it. That's the first method of amending the Constitution under Article 5. But the second method is the one I want you to also know quite well. The second method is, certainly my father believed, when the Congress refused to act. A lot of people today think Congress doesn't act like it should. Well, there's a second method of amending the Constitution. I think our framers were brilliant in putting the second method in there. We've just talked about the first method, when 2/3 of the U.S. Senate, 67 senators, or 2/3 of the U.S. House, 290 of 435 members of the U.S. House. We've been over it before, but there are 435 members, 435 members of the U.S. House. It takes 290 of them for it to be 2/3. That's what it takes for the Congress to move on a constitutional amendment. But the second method is when the states move. Or, that's the first. The first is the Congress. Or when 2/3 of the states, which is 34 of 50 states, call for a national constitutional convention, an amendment convention, to make a change. Once the amendment is proposed, so we have the amendment convention, 34 of the 50 states demand it, so assuming they meet in Washington, we now have an amendment convention. It's frequently called a constitutional convention, but that implies that the Constitution has already been amended. I think it's clearer to call it an amendment convention. 3/4 of the states, or state legislatures, same thing typically. 3/4, which means, again, 38 of the 50 states, 34, because 38 is coming in a minute. 34 of the 50 states have to call for an amendment convention. This is when the states, 34 of them, are sick of what's Congress doing. Congress, you'll never act, you never move. We need to address this, and we, the states, are taking the lead here with the second method of amending the Constitution under Article 5. Again, 34 of the 50 states call for an amendment convention, then they meet and say an amendment is proposed, say term limits. Right now, there aren't any. And you can be removed by the House you're in. We've talked about all that, but there is no term limit amendment to the Constitution. And it's going to take one if we're ever going to limit it, because I cannot see our elected officials deciding themselves to limit their own terms in office. It's just probably too much to ask. But the states can do it. When 34 of the 50 call for it, say, Washington, we're telling you we're doing this. We're calling for an amendment convention. 34 of the 50 states call for it. Then everybody meets. An amendment, say, for term limits is proposed. Then if 3/4, it took 2/3 to call for the amendment convention, 34 of the 50, it takes 3/4, which is 38 of 50. 34 of 50 to call for the amendment convention, but 38 of 50 to actually grab that amendment that was proposed and make it part of the Constitution. 38 of the 50 states, which means if 13 states say no to term limits, for example, that's 37, only 37 have been willing to ratify. We won't have an amendment to the Constitution which limits the terms of lawmakers. But if 38 do, if 38 states will ratify that amendment for term limits that came out of the amendment convention, if 38 of the states, as it makes its way around, if 38 of the 50 will say, you know what, we want, our state is demanding that term limits be a part of the U.S. Constitution. We're going to ratify this. If 38 of the states do that, then term limits, a constitutional amendment requiring term limits, would become part of our federal Constitution. So those are the two methods. It's tough. Number one, when the Congress does it, it requires 67 senators and 290 of the 435 representatives to call for it. But more likely, it will be the states. Again, the second method. If 34 of the 50 states call for an amendment convention, once they're there, an amendment comes out, then if 38 of the 50 states will be willing to ratify, it becomes a part of our Constitution. And that's how we amend the Constitution. It's tremendous. It's brilliant. It's difficult to do. I think it's supposed to be difficult to do. All right. Article 6. I may be able to finish this. We have 6 minutes until we go into the question and answer session. Article 6. All debts or contracts or agreements that happened before the Constitution was adopted and ratified will be honored in the new Constitution. That was mainly aimed back at the transition from the Articles of Confederation to the new Constitution. Any agreements made by our government before we had a Constitution would be honored after we had. Secondly, the Supremacy Clause. This is important. When state law is in conflict with federal law, a lot of people don't like this. If you favor strong states' rights, you may not like this, but it is in the Constitution. I'm willing to live with things that are actually in the Constitution. The things I have a hard time with are things that aren't in it and get made up. But we'll talk about that later. The Supremacy Clause is actually in the Constitution. And the gist, again, is that when state law is in conflict with federal law must prevail. The framers thought if we don't have a Supremacy Clause, then all these states will be knocking heads and will never have a cohesive society if the states never have to yield to the federal government. And they do based on the Supremacy Clause. And Congress will look and see, has Congress, the federal government, has Congress regulated in an area? If it hasn't, then the state law may be able to prevail. But if it has, Congress is going to require what's called, it will invoke the doctrine of preemption. The doctrine of preemption. And one of the best examples of the doctrine of preemption is in the area of nuclear energy. The federal government, Congress, has said, states, we are going to regulate the dangerous, the safety aspects of nuclear energy. So we have preempted all the states. States, you can go and pass laws if you want to, but you shouldn't waste your time because we are going to preempt the whole field here. There won't be any state law in the area of nuclear power, nuclear energy, and the health and safety regarding nuclear energy. That's the doctrine of preemption. The federal government has preempted the states in the area of nuclear power. Another aspect of Article 6 is that all federal and state officials, judges, elected officials of all kinds, all have to abide by the federal Constitution. Even though you're just a state court judge or a state representative, you may have to abide by your own state constitution too. In fact, you will, but you're also obligated to abide by the federal Constitution. So that's, again, the way the framers, and it's in here, so I can live with it because it's in here in plain black and white. I can understand the framers thinking, you know what, if all they have to do is follow their own state conventions, but not the federal Constitution, not convention, excuse me. If all states have to do is require their elected officials to follow their state constitutions and not the federal Constitution, again, it's going to be crazy. It's going to be all conflicted. It won't be cohesive. It will be hard to have a union in the sense that they were trying to set it up. But again, a co-equal union. Keep in mind, federalism is a system of co-equal powers. The federal government, the central government, and the states are co-equal. That's what I want you to know as much as anything else. That's how it is supposed to be, even though many times we'd have to wonder if it is. So, but we still have to obey the federal Constitution. State and federal officials do at every level elected officials have to adhere to the federal Constitution, as well as their state constitution. And the last part of Article 6 is that there can't be any religious litmus tests. You cannot, and again, keep in mind, they broke away from Great Britain. We broke away from England. One of the reasons we did that is because of religious persecution. People didn't want to be forced to worship to a state religion. So now that we're in our new country with our new constitution, we're not going to require a religious litmus test to run for office, to serve. Our public officials aren't going to have to be Methodist or Christian or Jewish or Muslim or anything to be able to run and serve in public office or be appointed a public official. We're not going to do litmus tests in this new country. We will not do religious litmus tests in our new country. I can live with it. Why? Because it's right there in the Constitution. No religious litmus tests. So that wraps up Article 6. All Article 7 really is the framers were wrapping up saying we need 9 of 13 states to ratify this Constitution. 9 of 13 states. New Hampshire became the 9th state, making it enough to, at least among those states, the 9, have enacted and be willing to live under the dictates of the U.S. Constitution. Later, both North Carolina and Rhode Island ratified when we did do the first 10 amendments, when the framers then sent out the first 10 amendments, the Bill of Rights, we call it, to the states to be ratified. At that time, I think North Carolina and Rhode Island felt assured enough as states to join the federal Constitution because they saw the first 10 amendments. But that's what it needed, 9 of the 13 to begin, to say we have enacted a new Constitution. And that's really what Article 7 stands for, the proposition. So it is 7:01, and I'm going to see if there are any questions. We have finished the articles. The first 7, there are 7 articles. We have done them all, and I hope you will review them to get in your mind. Some of them do jump around more than others, but what we've been through these first 4 sessions has been the body of the United States Constitution, the 7 articles, and they cover a lot of ground, and a lot of law has been enacted based upon them in the last 243 years. But those are the 7 articles of the body of our Constitution. And when we begin again in 2 weeks, we'll start with the First Amendment, the mighty First Amendment. And I hope you'll be back because it's going to be exciting. All right. Let me see what our questions are from tonight. All right. Here's one. That's a good catch. They want about the full faith and credit clause. Why does the full faith, and this question says, why does the full faith and credit clause apply to states if we don't agree we're supposed to be our own state? That's the question. That's true. It's a great question because that question, thank you, Karen. Thank you, Karen, for that question. That question brings again to light the idea that we have 50 states, which are their own body of federalism, and they're co-equal to the national government, to the central government, judicial, executive, and legislative. They're all co-equal, and that's why that's a good question. And the answer is, except if the Constitution addresses it, the federal Constitution addresses it, then essentially the issue is taken away from the states. To answer your question, that's why, for example, the full faith and credit clause. Again, I may not agree with what the definition of marriage is in New Jersey. I may not agree with what the correct age of a marriage is in New Jersey or Mississippi. I may not agree with how New Jersey or Mississippi or any other state handles child custody. But because of the federal full faith and credit clause, Louisiana has to give force of law to that decision from New Jersey or Oregon or Mississippi or any other state. That's what full faith and credit means. Again, what it means is Louisiana is recognizing the co-equal status of a fellow state. And again, I may not agree with it, but the full faith and credit clause is right there in the Constitution. And I can live with it because it's right there. We don't have any choice but to live with it. Article 4, Section 4. And I mean, Section 3, I was looking at the guarantee clause. But anyway, the full faith and credit clause. But Louisiana is still free, or any other state is still free to do a number of things on its own that are not reached by the federal government. And believe it or not, there's some areas that aren't reached by the federal government. Louisiana is still allowed for our own state to define the age of marriage. Louisiana is still allowed for our own state. We can't completely prohibit abortion, for example, but we can restrict it, as we've done. We can require a waiting period in this state. On the ballot on November 3rd is the Love Life Amendment, which means if Roe versus Wade is ever reversed and the decision about abortion is left to all 50 states, where it should always have remained, in my view. That's why one of the reasons I think Roe versus Wade is so wrongly decided, because it federalized the abortion issue. Those 7 Supreme Court justices said, we're taking the abortion issue from the states, which I think was a flagrant violation of the separation of powers. And it violated our system of co-equal federalism. Let Louisiana decide about abortion. Let California decide for itself about abortion. Let New York State decide for itself about abortion. The states that want to have some restriction on abortion can do it or have no abortion. And the others that want to allow for access to abortion, they can have it. I'll never think abortion is moral or correct. I'll always think it's wrong and evil and immoral. But I could respect each state deciding, because that's what our Constitution allows for. So again, I'm always going to have my personal view of the abortion issue. I think it's wrong. I'm staunchly pro-life. But before 1973, before the Roe v. Wade decision, the states were allowed to decide. Many states, like Louisiana, would virtually completely abolish abortion. But some would take a medium ground. Some, like New York State, which now has basically an infanticide law. The baby can, in the 9th month, the attempt on an abortion can take place. If the abortion fails and the baby's born, you can just leave it to die on the delivery table. I mean, it's sickening, but that's the full spectrum of abortion law in the United States. New York State is way broad on the other end of where, for example, Louisiana is. So again, the correct view is for Roe v. Wade to not have been decided. I think it was arrogance on the part of the U.S. Supreme Court to say, we're going to decide the issue of abortion for all 50 states. We're not going to leave it up to the states. And I think the correct position would have been to leave it up to the states. I think, again, many states would have had it outlawed all this time, and other states, based on their state legislatures and the people who live in that state, might have decided, well, under certain instances, we're going to allow for abortion. My point is, that's how it was before 1973. The states decided. I can respect that. That is a constitutionally valid, a constitutionally legitimate way to handle the abortion issue. Anyway, that's what the full faith and credit clause does. That is what leaving certain things to the states. Some states regulate the Second Amendment. Some states make it harder. You cannot completely abolish the second firearms, handguns, things like that, but you can restrict it. The Supreme Court has allowed. Well, we don't do much restricting of the Second Amendment in Louisiana. We're a very pro-Second Amendment state. So is Texas. So is Mississippi. But there are some other states who would regulate guns completely out of existence, but for the U.S. Supreme Court saying, can't do that. The Second Amendment is very clear. What don't you understand about the right to keep and bear arms shall not be infringed? So some states further regulate the Second Amendment than we do. We're wide open. Again, states get to determine those things. That's the correct, constitutionally valid way to do that. Let's see, another question. All right, here's one. What about, why is it so hard to allow states like, this is from Daryl. Daryl, thank you. Why don't we allow the rest of the territories to become states, like we did the Philippines, to become countries or states? The Philippines, we allowed it to become a country, but we have DC, Guam, and Puerto Rico, which are American territories. And Daryl's question is, why don't we allow them to become states? Well, they could, but you just have to build enough political support for both that state or the city. Enough people in Washington, D.C., the District of Columbia, has been trying to do this for a long time. D.C. has been trying to become a state for a long time. And but for the strong language in the Constitution that D.C. is to be a federal district, but for that, I think D.C. would have been a state. The District of Columbia, not Washington State. Of course, Washington State has been a state for a long time. I'm talking about Washington, D.C. But for that strong language, I think D.C. would have been a state a long time ago. But it's supposed to be a federal city. Until the Congress agrees and until the D.C. government, the citizens of D.C. agree, well, they already want it. It's the Congress. The Congress would have to allow D.C. to become a state. And I can think of a bunch of reasons why it should not become a state. Not the least of which is that the framers intended for it to be the federal city, a federal city, the nation's capital, and all those things. That's why. But to answer your question, Daryl, DC, Guam, and Puerto Rico could become states. They're American territories now, but they could become states if the right political entities come together and say, we're going to make them states. So that's the long and short answer of that. Let's see what else. We've talked about treason. I'm going to look at any other questions. And again, here's one from Sarah. What is diversity jurisdiction? This is so important. This, I think, is the last question for now. Diversity jurisdiction. There are essentially two ways to get into federal court. I'm saying that broadly for purposes of our discussion. There's more to it, as there always is, but for our purposes, there's two main ways to get into federal court. Federal question jurisdiction, which is the federal constitution, federal statutes, and treaties. Those are the three main ways that federal question jurisdiction is conferred upon federal district courts, gives them the power to hear a case, the jurisdiction. That's federal question jurisdiction. Diversity jurisdiction requires that citizens from two different states. My friend in Dallas, if he and I have a contract and he gets mad at me, he knows I live in Louisiana, he can sue me. He could sue me in federal court in Shreveport. And we're citizens of two different states. He's a citizen of the state of Texas. I'm a citizen of the state of Louisiana. He can sue me in federal district court because we're from two different states. And if a certain amount of money, what they call the amount in controversy, the requisite amount in controversy, I think it's about $75,000. Say he and I had a computer business. My friend James in Texas lives in Dallas, is suing me in federal court in Shreveport. I live in Louisiana. I'm a resident of Louisiana. He is a resident of Texas. We're in federal court in Shreveport. As long as $75,000 is in dispute and we're both citizens of different states, he can sue me in federal court here. Why is that important that James be able to sue me here? Although I would like James not to sue me. Why is it important that he be able to sue me in federal court in Shreveport? Because the framers intended that citizens of other states not be treated less well than the citizens of this state. We have all sorts of protections, the privileges and immunities clause we talked about earlier, but in court, in a state district court in Shreveport, I would probably be known better than James would, who lives in Texas. He might be worried if he sues me in state district court in Shreveport, the judge who is, even if we have a jury, we elect judges. Maybe Royal contributed to that judge. Maybe the judge likes Royal more than he likes me because I live in Texas. To get around all that, I think the framers brilliantly allowed for James to sue in federal court in Shreveport. Remember, federal judges are life tenured. They're there for life. They never have to be elected. They don't have to do anything but not have poor behavior and have 67 senators impeach and remove them. As long as they don't make 67 senators mad at them, they don't ever have to run for office, and their salaries can never be diminished. So they're insulated. Federal judges are insulated. So if James wants to sue me in Shreveport, he can sue me in federal court, provided $75,000 is in controversy, and he's a citizen of Texas. I'm a citizen of Louisiana. He can sue me in federal court in Shreveport, and that judge is much more likely to not care a bit that I'm from here and that James is from Texas. And I mean the federal judge in Shreveport. They don't have to care. They don't ever have to run for re-election. They don't ever have to raise money. They don't ever have to build political support. They're there for life, except if they're impeached and removed, which is very rare. Federal judges are there for life. So James should get the same even handling, fair shake that anyone from Shreveport would get. And that's why federal courts are set off in the way they are. So that is all the questions I see tonight. I know we scooted through the last of those articles because our time was cut a little short because of the computer glitch, but I hope that you have gathered and gained information regarding the first 7 articles. Keep in mind, if you ever have a question, you can email me, constitution.royalalexander@gmail.com. If you email me with any questions, I'll answer them. We are going to go on to the First Amendment, the mighty first. So much is tied up in the First Amendment. I hope you will join us next time. And if you want to go back over any of these sessions, I hope you will, so you'll know what the 7 articles of the Constitution mean, because we're going into the First Amendment next time. So thanks again for joining us, and I will see you in 2 weeks.